So what I've been saying up to now essentially is that the assumption that, at least up to a few years ago, that Western liberal democracies had solved the problem of the relationship between religion and human rights, or between religion and constitutionalism, that does not seem to be the case any longer. So the notion that you simply applied an idea of secularism, for example, as the solution doesn't seem to be resolving the tensions in the way that it had been expected to be solved in the past. That's the argument that I've made up to now. And yesterday then, I tried to explain when these cases get to courts, what are the elements of the controversies that most make it difficult for courts to engage and solve these kinds of disputes. So as you said, today I'm supposed to produce some sort of resolution of this. And some of you will know, any of you who've done Greek tragedy, or Greek theatre, ancient Greek theatre, will know that at some point, once the dramatist has constructed these impossible dilemmas for everyone, that at some point the dramatist then produces this solution, which no one expected, which comes out of the blue. And that's been called a deus ex machina. Right? So the god comes from the machine and solves everything. So if that's what you're expecting, you're going to be disappointed. Right. So there is going to be no deus ex machina. What I'm going to try to do is to draw together some of the themes that we've already been looking at, and to construct them and bring them together in a way that we haven't looked at so far. And to, in that way, draw out some possible themes for ways of addressing the problem, not solving it. Okay, so what I want to do to start with is really to begin where we ended yesterday, which was thinking about how the issues that we've looked at so far fit within the broader question of human rights. So there was a very pertinent question yesterday about the theoretical foundations of human rights generally, and that's what I want to start with, because it seems to me that one of the problems that we haven't really addressed so far is how far the questions that we've been looking at actually throw back into the human rights context fundamental questions about what human rights is for, more generally. So that's where I want to start. Now, one of the approaches, one of the issues that was raised in the first session was this relationship between human rights law and the philosophy of human rights. In particular, how far, in order to produce, if you remember those of you who were there for the first lecture, the question was how far in producing a satisfactory human rights law or human rights court decision you need to be constructing, you need to be satisfying a philosophically convincing understanding of human rights. So how far, in other words, to put it bluntly, how far does human rights law have to satisfy human rights morals? Yeah? And by morals, I'm using it in a broad sense of ethical, philosophical considerations. So initially what I want to suggest is that there are two kinds of approaches to that specific issue about the relationship between human rights law and human rights morality. And that the first of those is unsatisfactory but very common. And the second is intuitively not very attractive but probably right. So the first approach, and I think the approach that was actually suggested, at least hinted at, inferred, by the question the first day was the idea that the legal sphere is essentially a subset of the moral sphere. So in other words, that human rights law is really just a way of implementing in a particular context human rights morality. So from that point of view then, the law in this context derives from the moral considerations, the ethical considerations that underpin human rights. So in other words, when the courts, for example, are trying to decide what to do in a human rights dispute, the implication of that would be that they should effectively use the same kinds of philosophical tools, the same kinds of philosophical and normative considerations that one would do when one does morality, when one works out what is a morally, ethically satisfactory solution. So essentially then, human rights law becomes simply, as I say, a subset of human rights morality. And it's not at all surprising that people will want to argue that, because as we've seen, one of the reasons why human rights law has the impact not necessarily in practice, but the impact psychologically that it does have, why people want to argue for human rights, is because of the moral weight that it carries. Right. So it's not often that it's just being argued that we should be respectful of human rights because it's law, but also because we think it's right. So one can understand, therefore, why one would want to suggest that human rights law is a subset of human rights morality. But the problem is, or one of the problems is, that in suggesting that, it's not very clear what's actually meant. So one way in which it might be meant is that some of the concepts that human rights law and human rights morality share are the same kind of concept. So, for example, it might be, and it's probably the case, that the concept of a right, not the substance, but the concept of what is a right, is something that is shared between the moral system and the legal system. In other words, that the structure of what we mean by a right is similar in these two systems. And some very prominent philosophers have argued precisely that. So Joseph Raz, who's a philosopher of law that some of you may have come across, and more recently Samantha Besson from Switzerland, I have to say a former student of mine, a wonderful former student of mine, who's now a professor in Freiburg in Switzerland, says the following. She essentially adopts Raz's account of what a right is. And this is quite technical. So I'll read it to you and then explain what it means. So X has a right, X, the famous X, has a right, if and only if X can have rights, and other things being equal, an aspect of X's well-being, his or her interest, is a sufficient reason for holding some other person to be under a duty. Okay? So that's quite a technical explanation, which essentially gives you no substance as to what the rights are. It simply is a way of setting out the architecture of what the right is, of what a right is. And what she suggests is, and I think it's right, that that is a common concept between the moral sphere and the legal sphere. That generally what we mean by a right in law is that, and generally what we mean by a right in moral systems is that also. So in that sense, it's clear that there is a connection, and a strong connection, between human rights law and human rights morality in using shared concepts together. But some people, including Samantha Besson, want to go further in making this connection. Not just that there's a shared conceptual structure, but something much more essential about the connection. So what Raz and Besson want to argue is that for a thing validly to be called a human right, the claimed legal human right must be capable of also being a moral human right. In other words, it's a category mistake to say X has a legal human right if at the same time you can't also say X has a moral human right. So that's a strong connection then between human rights law and human rights morality. That's the real key to understanding what people mean when they say the legal system is simply a subset of the moral system in the human rights context. Now, the problem with that is that it leaves out of account some fundamental aspects of human rights law practice. Right? So from human rights law practice, it simply is not the case that everything that would be described as a human right in law is that kind of being that is also a moral human right. And let me give you one example to illustrate it, but it's only one example. So recently there was quite an important decision in the European Court of Human Rights where Russia was found in violation of human rights because of its treatment of the Yukos oil company. And this is quite an important decision because there was a lot of money involved. And Yukos oil company in Russia, I don't know how many of you are from Russia, but is a very hot political topic as well as an economic topic. And basically the allegation was that Russia had denied Yukos a right to fair trial and a right to protection of its property. And the European Court of Human Rights upheld that claim. Now, just think about that for a minute. What it decided was that the oil company had a legal right, a human right under the convention, to a certain treatment. Now, some of the bright sparks among you are going to think, well, that's okay, because really what you're doing is protecting the individuals in the company. No. No. That's absolutely not what was going on. It was the company that was protected, not the individuals in the company. It wasn't the directors of the company that were being protected. It wasn't the shareholders in the company that were being protected. This was not reducible to a set of individuals. This was the company that was protected. Right? That's what we call a legal person. We have legal persons in law, and we have real persons in law. This case was a protection of a legal person. Now, I suspect that very few philosophers, very few moralists are going to say that Yukos had a moral human right in that context, because we generally don't attribute moral human rights to legal persons, right, to entities, to companies. But in this case, this is not a marginal decision of the European Court of Human Rights. This is what they make these decisions all the time. So companies have freedom of speech requirements. Companies have fair trial requirements. The company does, not the individuals. So that's simply one example of where the legal practice doesn't seem to conform to the notion that every human right that's labeled a legal human right therefore has to be moral. Okay. So let's shift to the other extreme. Yeah. So
I'm sorry, Chris.
Please.
Let's always, scusate, per l'audience italiana meno forte, diciamo, nella comprensione della lingua. Allora, uno dei punti più provocatori di queste lectures è certamente quella di farsi parecchie domande intorno a che cosa siano i diritti umani. Alzo in piedi così almeno. I diritti umani, cioè normalmente immaginiamo che sia una specie di Vangelo moderno, contemporaneo, e a nessuno verrebbe in mente di mettere in discussione o di pensare che ci sia tanto da dibattere rispetto a un concetto che è così universalmente, diciamo, condiviso. Cioè, nessuno si sentirebbe di dire non so cosa siano i diritti umani o mi disinteresso dei diritti umani. Invece la domanda con cui stamattina Chris ha cominciato la sua lezione è proprio che cosa siano i diritti umani, soprattutto in relazione all'apparato morale. Cioè, quando parliamo di un diritto umano, ne parliamo soltanto in termini giuridici o ne parliamo anche in termini morali? Quanto le due cose coincidono? Allora, ci sono delle elaborazioni teoriche attraverso le quali si cerca di stabilire una perfetta corrispondenza tra queste due, o quantomeno di dire che i diritti umani sono un sottoinsieme della filosofia dei diritti umani che moralmente li descrive e li comprende. Quindi ciò che è giuridicamente protetto come diritto umano è anche moralmente giusto. E quindi Chris ha fatto degli esempi rispetto a chi cerca di costruire un sistema per trovare questa corrispondenza. Il caso naturalmente che guasta questa impostazione è quello che è stato appena citato, deciso qualche tempo fa dalla Corte Europea dei diritti dell'uomo, quando una società petrolifera tra le più potenti della Russia ha fatto ricorso alla Corte Europea dei diritti dell'uomo con riferimento alla presunta violazione dei diritti del giusto processo e quindi insomma di essere adeguatamente rappresentato durante una controversia. E la Corte Europea ha dato ragione alla compagnia petrolifera dicendo sì, è vero, il governo russo ha violato i diritti protetti dalla Convenzione, in questo caso invocati da una società, diciamo appunto come società, insomma per fini di lucro, e in questo caso forse è evidente quanto si apra la discrepanza tra un diritto umano concepito giuridicamente e invece un diritto umano concepito moralmente, perché molti di coloro che stabiliscono la connessione tra ciò che è giuridicamente protetto e ciò che è moralmente giusto troverebbero qualcosa da ridire guardando a un diritto umano che in questo caso non è stato attribuito a un individuo, ma è stato invece attribuito a una corporation, quindi a un grande centro di interessi economici, che non è esattamente l'immagine del titolare dei diritti umani che diciamo in prima battuta ci può venire in mente. Quindi questa è la prima ricostruzione, cioè andando a cercare le fondamenta dei diritti umani, la prima ipotesi è quella di trovare in loro una corrispondenza con un sistema morale universale, che però facilmente viene messo in crisi.
I mean, in fact, I could go further and say that in some arguments in morality, some people would go so far as to say that not just that the company shouldn't be regarded as having moral rights, but that the company shouldn't have legal human rights either. But let's leave that aside for the moment. Okay, so the other possibility then of this relationship between the law and the morality, as it were, of human rights, is to think of them as operating in separate spheres, entirely separate spheres. So what are the implications of that? Well, let's think initially of what we mean by human rights law as being a normative system. And you remember yesterday what I was suggesting was that there were two normative systems operating in the religious and the human rights context. Let's think a bit about what we mean by law as a normative system. And we can think of it in two different ways. So one way in which we can think of human rights law as being normative is what lawyers commonly think of, that it's a normative system because you should do according to what the law says. Right? So why should you do what the law says? You should do what the law says because law has a degree of authority within its own sphere. So law is a normative system insofar as it fulfills the category of what we mean by law. Now, I'm not saying that it's normative in the sense that it's morally required that you should obey the law. I'm not saying that. I might say that, but I'm not saying that now. I'm simply saying that in its own system, law thinks of itself as being normative in the sense that one should follow it within its own system. So, from that point of view, what it means is that once you pass the test of what it means to be law, then it becomes normative in its own terms. So what does it mean for something to be law? Well, it has to pass some test, right? Some identifying test which separates law from not law. Yeah? So there's lots of systems of rules all over the place. What makes one set of rules law and other sets of rules not law? And of course, this is a huge question in legal philosophy, which I'm not going to get into in any major way today. But there are lots of tests out there as to what constitutes law as opposed to non-law. One way of thinking about it, and it's, was brought up in the Oxford tradition, so I'll use that as one way of addressing it, is to say that what law is has to pass what Hart called a rule of recognition. Right? That systems out there, social systems, political systems, have a set of criteria, let's call it a rule of recognition, that recognizes some kinds of rules as law. Generally, one can describe it, relatively simply in most systems. For example, if a law gets passed, if a set of rules get passed through Parliament, then most systems recognize that as law. Equally, in the common law context, certain decisions of courts are regarded as creating law. Right, the judges, this is the notion of common law. So there's usually a kind of complex set of rules setting out what is law and what is not law. Let's call that the rule of recognition. Now, this is where it gets, if I may say, a little bit more complicated, because the rule of recognition of particular legal systems may indicate that part of what we mean by law incorporates some notion of external morality. So external morality is, as it were, imported into the rule of recognition. So think about some of the decisions that we were looking at yesterday in the human rights context dealing with religion. And what we see is the courts drawing on concepts of dignity, concepts of justice, concepts of equality. And all of those, of course, are both internal to the legal system, but they're also external to the legal system. And some legal systems, in fact, I'd say most legal systems, when you're interpreting these concepts, they'll draw on understandings of these concepts from outside the legal system as well. Judges are not automatons. Judges are not robots. They are living in the society. They have lived experience. And therefore, it's not surprising that they're going to be influenced psychologically by what's going on. I'm saying more than that. I'm saying that the legal systems incorporate to some extent into the rule of recognition of what law means in a particular context, understandings from the moral sphere as well. But that's a decision of law. That's a decision in each particular case to what extent moral considerations are regarded as relevant to legal reasoning. That's an internal legal decision. So when we say then that law and morality are separate spheres in the human rights context, that law is not simply a subset of morality, we shouldn't go to the opposite extreme of saying there's no connection whatsoever between human rights law and human rights morality. Because in some cases, most of the cases that we were looking at yesterday, the courts are actually incorporating a degree of moral reasoning into their legal decision. Now, they're not being philosophers. They're incorporating a degree of moral reasoning into their system because the rule of recognition permits them to do that. They are acting as lawyers, they're acting as legal implementing mechanisms. They're not acting as philosophers. But nevertheless, they are drawing on morality. More than that, of course, because they are making these kinds of decisions, they also contribute to the development of moral reasoning in the larger society. So when the European Court of Human Rights decides a particular issue, or when the United States Supreme Court decides a particular issue, or when the Italian Constitutional Court decides a particular issue, it isn't just deciding it for law, it's also affecting the way in which the larger society is going to regard the moral question. So it's, in other words, it contributes to the moral reasoning. Now, that is entirely an empirical question as to how far it does or doesn't. But it would be a mistake, I think, in most systems to think that there's no connection. Okay, so what I'm suggesting then is that we have a complex picture of relationship here between the law of human rights and the morality of human rights, in which there is interpenetration, but in which they operate as separate spheres interpenetrating. Okay. Yeah, do you want to?
Yeah.
Because I'm conscious that I'm throwing a lot here.
Allora, abbiamo visto la prima possibilità, che è quella di spiegare i diritti umani come un sottoinsieme del sistema morale. Dall'altra parte viene vissuta la tentazione esattamente opposta, cioè di immaginare i diritti umani completamente separati dalla morale. I diritti umani sono patrimonio protetto giuridicamente che non risente affatto dell'impostazione morale. Però Chris ci mette, ci mette in guardia rispetto a questa radicalizzazione della separazione tra morale e diritto, perché quando ci chiediamo perché una legge è considerata legge, perché una norma è considerata norma, normalmente si rifà a un famoso filosofo del diritto che aveva la cattedra, che ha avuto la cattedra ad Oxford per molti anni, che si chiamava Hart, il quale diceva che norma diventa quella che supera un test, diciamo così, di riconoscimento come norma. Cioè delle volte basta che una norma venga approvata e quindi entri in vigore dal Parlamento per poter dire che quella è una norma, che quindi è vigente in quell'ordinamento. Questo è un requisito, un metodo di riconoscimento formale. Però ci sono anche altre modalità di contribuire all'individuazione delle norme e queste modalità possono trarre ispirazione da riferimenti morali che i giudici possono trarre dal sistema nel quale operano. E quindi, anche perché Chris l'ha appena detto prima, i giudici non sono né robot né alieni, sono persone inserite in un determinato contesto che è fatto anche di una certa sensibilità morale, per cui quando devono individuare ed applicare delle norme possono farlo anche facendo riferimento al sistema morale di quel contesto. E quindi attenzione a, diciamo così, procedere all'estremo opposto, pensando che ci sia una netta separazione tra i due sistemi, perché spesso è proprio il diritto stesso, gli operatori del diritto stesso, che decidono di attingere al patrimonio morale di quel contesto per aiutarsi ad identificare le norme. E quindi con questo meccanismo la netta separazione, l'impossibile contaminazione tra le due è una visione molto manichea, molto estrema e poco aderente a quello che in realtà capita.
So the conclusion that we need, sort of sub-conclusion that we need to make at this point is that in terms of understanding what legal human rights are, we need to be extremely conscious of legal practice. So legal human rights are carried out in an institutional context. And when the courts are operating, they're operating in an institutional context, which is governed by its own set of acceptable norms, acceptable practices. It's not immune from external influence, clearly not, but it's operating according to its own rules and practices. Now, that's legal human rights for the moment. So, what about human rights generally? And remember, I said at the beginning that I wanted to talk about the foundations of human rights. So, there's an equivalent debate, sort of equivalent debate, in recent philosophical discussions about the meaning and understanding of human rights. And the distinction that's made between these two different groups of philosophers is between those who adopt what's called a practice-dependent approach to human rights, and those who adopt what's called a practice-independent approach to human rights. Now, by a practice-independent approach, so bear with me for a minute, right? This will become clearer. I know the language is unfamiliar to some of you. I mean the language of practice dependence, I don't mean the language of English. So the practice-independent approach is essentially saying the way we should understand human rights is by arguing from first principles. So it's a priori reasoning based upon a certain set of initial premises from which then we derive what we mean by human rights in a particular context. So that's, in a sense, what's often been called the orthodox approach, the orthodox philosophical approach. And that has a long tradition. So, those who thought about it in the natural law context did it from those premises. More recently, several other quite well-known philosophers, most particularly James Griffin, who's written a really very interesting book on the theory of human rights, essentially adopts this practice-independent approach, where you argue from first principles. And the consequences of that are quite powerful. So what effect it has is that when you derive from the first principles a set of what you think of as human rights, that's used as the basis for a critique of what other people are calling human rights. And so James Griffin is quite prepared to say, and does say, on the basis of my reasoning from first principles, some of what you out there are calling human rights clearly are not. They shouldn't be thought of as human rights. So, famously, there is a right in the Universal Declaration of Human Rights to paid holiday leave. Right? And he says, that's ridiculous. Right? How can you have a human right to paid holiday leave derived from the way that I derived human rights? That's not. Equally, he says, very skeptical about socioeconomic rights on the basis of these first principles. Right. So that's one approach. And what we've seen a lot of what was going on yesterday in terms of the religious context was arguing from first principles. Right? So when we talked about, for example, Catholic traditions, that's very much a kind of orthodox philosophical approach as well as a religious approach. You start from the notion of human dignity and you derive everything from that. Okay. So that's a practice-independent approach. And that is shared by some philosophers and quite a lot of theologians. There's an alternative approach. And the alternative approach is called practice dependence. Now, the key question here is practice. Right. So what's going on here? Well, first of all, I need to set that question in the context of who these people are who are arguing this practice-dependent approach. So essentially what's going on here is a philosophical tradition that derives largely from, in recent years, largely from John Rawls. So this is the John Rawls of a book called The Law of Peoples, not the John Rawls necessarily of justice, theory of justice. This is later Rawls rather than earlier Rawls, for those of you who are into Rawlsian history. So what Rawls says in The Law of Peoples is essentially that we should be deriving our understanding of human rights philosophically, not from a practice-independent approach, but rather trying to understand how human rights is practiced, and then extract from that what kinds of moral considerations underpin that practice that are acceptable. But you start from the practice, and then you try to extract the moral principles from that. Rather than a priori reasoning, you start from a premise and derive the practice from the premises. Now, what are the implications of that? Well, really very important. So there are two particular features of Rawls's approach that have influenced subsequent generations of philosophers. And these are not marginal. I'd almost say that certainly in Western philosophical theories of human rights, this is almost becoming a semi-dominant approach that challenges what I call the orthodox approach. So one of the features that Rawls says we should understand human rights by is in particular that it's better to understand it in a practice-dependent approach, because otherwise you're driven to adopting what he calls an orthodox approach, which are based on comprehensive doctrines relating to the human person. Why do we not want to do that? Well, I'm quoting now. They're based on a theological, philosophical, or moral conception of the human person, which is contested, which does not have consensus, and that the effect of rendering rights on the basis of that kind of approach is unacceptable to those who do not share these doctrines. So in other words, what he's essentially criticizing is very much quite a lot of what we were talking about yesterday. Given that it was practice independent, and we saw that one of the highly contested issues that we looked at right at the end was what I call the ontological issue, which is what do we mean by a human person? And what Rawls is doing is directly confronting that and saying it's precisely because it's so contested that we shouldn't be starting from there. So what does that have as an implication? The implication it has is that the way in which we should be explaining human rights to each other is not by resorting to these comprehensive approaches, but rather by using public reasons. We should be trying to convince each other as to what human rights we do or do not have. Now, this idea of public reasons becomes very important in the Rawlsian system, because what it does is essentially rule out those who are resorting to comprehensive doctrines that are not understandable to those others that you're communicating with, or which assume certain premises that are just unacceptable. So the notion of public reasons, therefore, has been used by quite a lot of philosophers to say, well, therefore, a lot of this religious stuff, a lot of these theological understandings of human rights are not based on public reason, and therefore are unacceptable. They shouldn't be thought of as engaging with what we're doing, which is we, rational, reasonable people, which is engaging in public reasoning. That is, reasoning that is acceptable, that's based on premises that are acceptable to a large number of people. In fact, what he says is that you shouldn't derive human rights from any particular comprehensive doctrine, whether religious, moral, or philosophical, but only on reasons that appeal to all decent people. Okay. After all, we're all decent people. Who's not a decent people? No, it's okay. So that's one issue. The second issue, the second feature of what Rawls is arguing, which is also very important in current debates, is that he essentially says we shouldn't confuse human rights with constitutional rights. So there's two different sets of things going on here. There's human rights and there's constitutional rights. They're different. So what does human rights do? Well, let's look, given that he's operating on a practice approach, let's look at the functions of human rights. And the functions of human rights, as human rights rather than as constitutional rights, are essentially only operating at the international level. So what are human rights? Human rights are a particular set of rights that essentially allow international intervention into the domestic sphere. So what are these kinds of rights that we're talking about? Well, essentially, he says, very narrow set of rights, what he calls particularly urgent rights, such as freedom from slavery and serfdom, liberty, but not equal liberty of conscience, security of ethnic groups from mass murder and genocide. That's it. So you derive your list of human rights from practice, and the practice is an international political practice which essentially allows intervention by the international community into the domestic sphere. So it's a functional explanation based on practice, which then derives a limited set of rights, because you only want to allow intervention in somebody else's backyard on the basis of particularly urgent rights. Now, he's writing, of course, 20, 30 years ago, so it may be, in terms of political practice, expanded since then, but it still is pretty narrow. Okay, so at this point we need to turn to another practice-dependent philosopher, writing in the Rawlsian tradition. And this other philosopher is Joseph Raz, whom I mentioned earlier on. And usefully what he does is to set out the operation of deriving a normative set of rights from this practice-dependent approach. And he essentially splits it up into two questions. First question, he says, is that we need to establish the essential features of what contemporary human rights practice involves. So what do we mean when we say we should be engaging in understanding human rights from political practice? We first of all have to decide what the political practice of human rights is as a descriptive measure. Right? So what is the practice of human rights if you're going to derive the normative set of human rights from that political practice? And then he says what you should then do is essentially to identify the moral standards which qualify anything to be so recognized or acknowledged. That's the normative bit. But for the moment I want to focus on the first bit. So what do we mean if we're going to have a practice-dependent approach to human rights? Why we want to do that? Because we're getting rid of comprehensive doctrines. So we want to focus on practice. What's the practice? Now, unfortunately, most, and I'm now going to be extreme, most, if not all, philosophers who are dealing with a practice-dependent approach have an incredibly narrow understanding of what human rights practice is. And even the most sophisticated, and there are a lot of, as you can imagine, very sophisticated philosophers out there who are doing human rights. And I've read quite a lot of them. They ignore largely two fundamental aspects of social practice of human rights that we talked about throughout the last 2 days. One, they very seldom take into account anything approaching a sophisticated understanding of judicial interpretation of human rights. Now, why would they do that? Because I'm afraid the understanding of human rights that they have is one which is essentially text-based. So they look at lists, they look at the Universal Declaration of Human Rights, they look at the International Covenant on Civil and Political Rights, they look at the International Covenant on Economic, Social and Cultural Rights, and then they stop. And of course, what we've been looking at over the last 2 days is precisely the point that it's the texts are the beginning of the conversation, not the end of the conversation. And that they always need to be interpreted. And that the interpretation is always controversial. And that it always involves choices. And choices among different interpretations. So to ignore this whole development of human rights jurisprudence is, from the point of view of a practice-dependent approach, is crazy. Absolute nonsense. That's the first point. I express this in strong terms. The second point that is largely ignored is, of course, what else we saw going on the first day, which is that there are lots of organizations out there, for example, NGOs, social activist organizations, churches, among others, operating as social actors who are doing human rights all the time. So again, to suggest or to ignore that whole area of the social practice of human rights is also crazy if what you want to do is to derive human rights from practice, and if it's a practice-dependent approach. So they may well be right in wanting to have a fresh start and not adopt the orthodox practice-independent approach. But if you're going to be practice-dependent, you want to be very sure that you've got an accurate understanding of what the practice actually is. Okay. So what are the implications of that? Do you want to...
Yeah. Anche per coloro che sono arrivati più tardi. Dunque, stiamo parlando dei fondamenti dei diritti umani e dei parametri, delle categorie con le quali cercare di stabilire un fondamento dei diritti umani, perché sono tutt'altro che autoevidenti. Chris parlava di 2 approcci che generalmente vengono riscontrati in dottrina. Il primo approccio è quello indipendente dalla pratica, cioè c'è un filosofo, qualcuno che riflette sui diritti umani e costruisce un insieme di principi sulla base dei quali organizza il concetto di che cosa siano i diritti umani. Quindi qualcosa di molto astratto e che viene costruito sulla base degli assunti che il filosofo di volta in volta ritiene i suoi punti di partenza. E quindi ci sono filosofi che dicono ma questo non è un diritto umano perché non rientra nella ricostruzione teorica che io ho pensato di mettere insieme. Dall'altra parte c'è invece la ricostruzione di che cosa siano i diritti umani basata sulla pratica. Però Chris dice che ci sono 2 limiti fondamentalmente, cioè chi basa la ricostruzione dei diritti umani in chiave più pratica, cioè guardando a quello che accade, a quello che c'è, non ad una costruzione teorica di quello che c'è, normalmente incontra 2 limiti. Il primo è che guarda soltanto ai testi, cioè prende la Dichiarazione Universale dei diritti dell'uomo, prende i vari accordi che sono succeduti alla dichiarazione, guarda i testi e dice ah bene, questo è l'elenco dei diritti umani, questi sono i diritti umani. E quello che lascia fuori da questa ricostruzione è invece tutta l'interpretazione che avviene in sede giurisdizionale da parte dei giudici di quello che i testi dicono. E allora Chris dice che i testi non possono essere il punto finale, ma non sono nient'altro che il punto di partenza, cioè posto che una disposizione protegge una determinata fattispecie di diritto umano, tutto quello che viene dopo è stabilire che cosa quella disposizione preveda, perché non è autoevidente, non è esaustiva, diciamo. Il secondo limite che la ricostruzione pratica, diciamo, orientata alla pratica incontra, è che in realtà non guarda veramente alle cose pratiche. Cioè non ha chiaro in testa che cosa significhi pratica, perché non guarda a quello che per esempio i tanti attori coinvolti nell'applicazione dei diritti umani fanno quotidianamente di fronte alle istituzioni, alle corti che si occupano di diritti umani. Quindi le tantissime organizzazioni non governative, le associazioni religiose, i movimenti che invece prendono parte ai processi attraverso i quali si invocano e quindi si chiariscono i diritti umani nella loro portata. Quindi diciamo in estrema, ingrata sintesi, però più o meno questo è il percorso che stiamo seguendo.
So where we've reached then, essentially, is if you want, and remember at the end of yesterday's session, there was a lot of questioning about whether you wanted to adopt, for example, notions of intrinsic dignity, and there was a lot of concern about doing just that, for reasons that essentially we now see Rawls also agrees with. So if you want not to go there, but to have an alternative approach based on practice rather than on practice-independent approaches, then that seems a possible way forward, but it requires you to have then a sophisticated understanding of what human rights practice is, and at least in three respects, we see that Rawls's approach is, from a practice-dependent approach, highly suspect. One, his distinction of human rights is only operating at the international level, is equally crazy, because what we see increasingly in legal practice is the interpenetration of constitutional rights and international human rights. The idea that they are now separate spheres, that they don't interpenetrate, is just nonsense in practice terms. Happens all the time. So the idea, therefore, that practice-dependent approaches will only focus on the use of human rights at the international level misunderstands the complex nature of the relationship in actual practice. That's point one. Point two, it requires you, if you're going to be a practice-dependent approach, to incorporate seriously the interpretive practice of human rights at the judicial level. We can no longer ignore that. That's not superficial. It's a fundamental aspect now of human rights practice. And that isn't just lawyers puffing themselves up. What we've seen in the first day is the fundamental role that human rights litigation plays for social actors. And thirdly, we need to take into account seriously, if you're interested in a practice-dependent approach, to the diversity, let's call it the pluralism, of human rights interpretive practice, not only between the courts and legislatures, but also the whole set of NGO activity, social activism, revolutionary activity that uses human rights and that has an interpretation of human rights. So, Arab Spring. If you looked at what was going on in the Arab Spring, what you saw, and you read the placards. First of all, it was interesting that a lot of the placards were in English. Why? Because obviously you're appealing to an international audience. But a lot of the placards also use basic human rights concepts. In particular, and this is in the Arab context, the Muslim context, they use notions of human dignity. Mm-hmm. So there's an interpretive practice of human rights out there that is a social practice of human rights. So in other words, what you're getting is a notion of human rights as a highly pluralistic system in practice, where there are legal interpretations, where there are international interpretations, Human Rights Council, where there are social practice interpretations. Human Rights Watch or Amnesty International have a very clear view of what they interpret human rights as being. It doesn't necessarily match either the international or the legal. They have a clear view as to what they should be. And we've also seen there are religious interpretations of human rights. So the notion that we started with, that it's human rights versus religion, we now need to take a lot more sophisticated approach. What you are seeing in practice is a whole pluralism of human rights interpretations that are all different. They overlap, but they're different. So what you're getting, therefore, is not human rights versus religion. What you're getting is a particular interpretation of legal human rights versus a particular interpretation of human rights from a religious point of view. But also, you need to add into that mixture a whole other set of interpretations based on social practice, like what the NGOs are saying, or what the Human Rights Council is saying. So you get a pluralism of human rights practice. So what are the implications of that? Well, what it seems to be accepting is the importance of a practice-dependent approach. But of course, what that means is that in incorporating or in understanding a practice-dependent approach, you need to understand that some of those actors are adopting a practice-independent approach. That becomes, right? That becomes a part of social practice of human rights. So the fact that some groups out there are adopting a practice-independent approach means that it has to be incorporated into our understanding of human rights practice. So what are the implications of that? Well, what essentially it means is we have to take seriously the pluralism of human rights practice. What it means essentially, therefore, is that we need to reconstruct what we mean by a practice-dependent approach. And that's what I want to do in the next few minutes. If you think I can go on. Yep? Okay. So let's start from in reconstructing this practice-dependent approach. Let's start from a different question. So I seem to be quoting H.L.A. Hart a lot. It's not that I'm a particular fan of H.L.A. Hart, but in this case, he's quite useful. So he wrote another book, called Punishment and Responsibility, many, many years ago. And what he was trying to do was to understand how you think about punishment as an institution. And what he said was, as an institution that may or may not be justified morally, what he said was, you need to understand it in two different ways. You need to understand it, first of all, from the point of view of what the general justifying aim of punishment is. And then you need to understand how it's applied in practice. How that general justifying aim is applied in particular contexts. And what he suggests, and this is an important point, he suggests that the distinction between the general justifying aim and the application may mean that different normative principles apply at these different levels. So famously, what he said was, and those of you who are conscious or understanding of debates within punishment, there has always been a debate about whether punishment is justified on utilitarian terms or on retributive terms. Yeah? So what he says is, actually what you see is the general justifying aim is generally utilitarian, but in certain contexts, actually you apply a retributive understanding and practice at a particular level. So, in other words, there's potential play in the system of different normative understandings coming in. So, think of that as applying in the human rights context. What would happen if you applied this distinction between general justifying aim and application? And what I'm going to suggest is that the general justifying aim of human rights, that they got it right in 1948, that the general justifying, and ever since in terms of the text, that the general justifying aim of human rights is human dignity, but it's a very thin concept of human dignity. It simply says there is value to the person. That's it. What that means in practice, that all is up for discussion. That's all to be decided. So it's a very thin, but nevertheless important, general justifying aim that gives a moral set of premises to the human rights project. But that after that, everything is to be determined. So what does that mean? Well, what it means is that what a lot of the different actors that we've been describing up to now are doing is engaging intentionally or unintentionally in precisely that debate of what the implications of this general justifying aim are. And that different results will arise from that, not least because these different actors are operating in different institutional contexts. So given that what we've seen is a whole variety of human rights practice, we've seen social actors operating in revolutionary contexts. Think of the Arab Spring. We've seen actors, human rights activists operating in courts. We've seen social rights activists operating in Human Rights Council, operating in the UN, wherever. It would be amazing if different results of understanding of what we mean by this general justifying aim hadn't emerged. It would be amazing if, given the different institutional contexts, the different results hadn't emerged. And that, of course, is precisely what we see. Different results. So what's the implications of that? Well, what I'm going to suggest further then is that the implications that we need to have for our new super practice-dependent approach is that we need to integrate the institutional considerations into our understanding of human rights practice. And that has important implications, which we'll look at in a moment. In particular, what it seems to infer is that there is a competition, therefore, in terms of the understanding of the general justifying aim of human rights. There are different, and for the moment, let's assume that there's no reason why we should prefer one rather than another. Because remember, we've already rejected the practice-independent approach of deriving human rights from first principles. So if we're not engaging with that approach, then there's no reason for the moment to prefer one interpretation rather than another. They are all interpretations of human rights, and they're all satisfying or attempting to satisfy in their own lights this understanding of the general justifying aim of human rights being a way of fulfilling human dignity. But of course, there's lots of other ways of fulfilling human dignity. You don't have to do it through human rights. Right? I mean, people were trying to fulfill understandings of human dignity long before human rights were invented. This is one method of doing it, but not the only method. Equally, legal human rights is one method of doing it, not the only method of doing it. Nodding from China. Okay. So what do we do with this diversity of practice then? What do we do with this pluralism? Well, essentially, we're all going to have to live together. Some of us may not prefer to live with other people, right? And that's why we slaughter other people. But the reality is, in any marginally democratic system that has any fundamental conception of human dignity, we can't do that. And so what do? Well, we have to construct some method of engaging in discourse with each other, with dialogue with each other. Now, be clear what I'm saying here. I'm not saying that you should adopt some sort of dialectical process. If by a dialectical process you mean that you're trying to resolve the problem of differences of interpretation. I'm not suggesting that. So I'm not naive enough to think that you can simply put people in a room for how many days and you're going to end up with an agreement. These are fundamental questions. Each of the questions that we looked at yesterday are fundamental problems, particularly the ontological problem. So what we should be looking for then is not a dialogic approach that results in a new thesis, antithesis, synthesis, a new synthesis, a new consensus. That's not going to happen. What I'm suggesting we should be accepting is that the discourse that's necessary, the disagreement that's necessary, is a fundamental part of what we mean by doing human rights. So in other words, what I'm suggesting is that the idea that there are all these different opinions out there, all this diversity, that's a problem. No. That's an essential part of the system. The fact that there is disagreement, the fact that we need to talk to each other about that disagreement, the fact that we know we're not necessarily going to reach agreement, but that we're going to have to live with each other nevertheless. That's what we mean by doing human rights. So in other words, the human rights language provides the space, provides some of the language, if you want, in which we can conduct that kind of discussion, in which the aim is not to impose our views on others, but to try to reach some sort of modus vivendi. Now, what the problem with that is, of course, and it may well be a problem, and I suspect some of you are already beginning to identify it as a problem, that may, you may think, lead to an understanding of human rights that is non-universalistic, and that is entirely dependent, therefore, on the local context, and therefore the whole understanding that we had of human rights as universalistic goes out the window. In particular, it simply reduces to politics. Yeah, and of course, one of the reasons why we have a system of human rights from 1945 onwards was because we saw consistently in this century and last century that human rights was failed by the political process, that we needed something else. So there's clearly a tension here. The only thing I can say is that that's the reason why it's important to have, however thin a notion, to have this notion of human dignity at the back. Because what it means is that we at least are discussing something in common, which is our understanding of what it means to be human and what that requires of each of us with regard to each other. So we've got a common aim here of trying to understand what the implications of this very difficult concept are. So that's the common aim. And to the extent that people are wanting to do that in good faith, then that provides the universalism. But it's a universalism that has to be unpacked day by day in different contexts. And that means a lot of work. Caroline's heard this story before. So when our children were small, right, it's very unfair what parents do. They sometimes listen to conversations that the children have, right, knowing that the children don't know that they're present. It's very unfair, but it's very, very, it's very instructive. Anyway, so we have two children, Kathleen and Joseph, and they were talking about, I think they must have been 7 and 8 or something. And they were talking about what they wanted to do when they grew up. And so I think it was Joseph said to Kathleen, so what do you want to do? And Kathleen said, I think at that time she wanted to be a ballerina at night and a painter during the day. I think it was that. And Joseph said, well, what about human rights? What about what Daddy does? And Kathleen said, oh no, I certainly don't want to do that. So Joseph said, well, why not? And the response was, well, you have to do it all the time. So what I'm suggesting is that she was right? You do have to do it all the time because that's what it means to do human rights. Okay, so what are the implications of that then for this set of disputes that we looked at yesterday and the day before? So this is all at a very general level of generality. So the question that we now need to look at is there a dialogue possible between secular understandings of human rights and religious understandings? Because I've so far said we need to have this dialogue if we're going to be serious about it. But of course, saying that something should be the case implies that it can be the case. Right? So if one was to conclude that actually no dialogue is possible, then what I've said is nonsense. And I'm sufficiently uneasy about my conclusions to want to know seriously whether a dialogue is possible. And I'm not assuming it is. I mean by a dialogue, a real dialogue, not just people talking to each other, but actually trying genuinely to understand each other. So is a dialogue possible? And of course it takes at least two, famously it takes two to tango. It certainly takes two to have a dialogue. So what we need to examine then is the extent to which there's a possibility of dialogue on both sides. Let's assume there are sides for the moment. And one of the potential problems here is what I'll call, provocatively, fundamentalism. But it's a fundamentalism that, I'm afraid, affects both sides, potentially. So there's a very interesting point that was made by I think a very good and interesting, I think he must be Italian, but you'll tell me if I'm wrong. So Giorgio Sacerdoti?
Sacerdoti.
Doci.
Yeah, he's Italian.
He's Italian. So what he said is, when he's talking about the understanding of human rights, he says the following. He says, the religion of human rights and fundamental freedoms has replaced other religious beliefs as the underpinning of social life in contemporary societies. And he's not alone, right? So Michael McConnell has said that there's a tradition in the human rights law tradition that regards human rights as a comprehensive ideology in which there are right answers to be found. And of course, quite a lot of, particularly I have to say, NGO activity is based upon that set of assumptions, that there are in fact right answers. And a sense of wanting to see it as a comprehensive view of how we organize ourselves. So if you have a comprehensive view, what we've already determined when we're talking about the problem with practice-independent approaches, what we've decided already is that one of the problems with religion is that it has a comprehensive view of everything. And if you don't buy into that, then you can't understand the system and we can't talk to you. But equally, I have to say, in the human rights context, there's a potential problem of also there being a comprehensive view, in which if you don't buy into everything, we can't talk to you. Now, this is all, particularly for a human rights practitioner, this is quite difficult territory here, because what I'm suggesting is that human rights advocates don't necessarily get it right all the time, including myself. And that we therefore have to have a degree of modesty here. So what would that mean then in terms of some of the disputes that we've been looking at up to now? What implications does it have for human rights law? And of course we need to come back at this point to the question about pluralism, secularism, secularity, that several of you have raised on both days. And what I'm going to suggest is that, very crudely, you'll understand there has to be a degree of simplicity going on here. But very crudely, there are two options on the table. There's secularism, and there's what I'll call secularity, which is another way of talking about notions of pluralism. And what I'm going to suggest further is that secularism threatens to become itself an ideological view. In fact, a comprehensive ideological view of how you should organize relations within a society. So what that means is that it's an ideology, secularism is an ideology that can manifest itself as opposed to religiously based or religiously motivated reasons for acting by religious actors, as hostility to religion in public life, and an insistence that religious manifestations, reasons, or even beliefs should be relegated to an increasingly shrinking sphere of private life. So you push it to the margins. Or even, in some contexts, what we're seeing is a kind of aggressive proselytizing atheism. So what I'm suggesting is that we might call that secular fundamentalism. Now, secular fundamentalism then becomes an ideology. It's not a creation of a neutral space, it's a positive understanding of how the space has to be filled. Contrast that with what I've called secularity. There are various terms you can use, but nothing much hangs on it, but let's call it secularity for the moment, which is essentially trying to provide a framework capable of accommodating a broad range of religions and non-religions. So secularity is a very modest concept. It's committed to creating what could be called a broad realm of constitutional space, in which competing conceptions of the good, some religious, some not, some opposed to religion, some not, can be worked out in theory and lived in practice by their proponents. So that comes closer to the neutral space that I think you were looking at. But those committed to what I've called secularity, why do they consider it preferable to secularism? Well, because essentially one should be skeptical of utopian visions adopted by states. So what we see in the past century, if not before, is that some of the worst excesses have resulted from the adoption of utopian comprehensive visions by states. And we should be skeptical of that. So the state shouldn't attempt to promote a pristine secular order where the public realm is scrubbed clean of all religious residue. That's either hypocritical, or it's a dystopian vision of neutrality. So it's essentially what should be excluded rather than what should be included. So the reason I'm suggesting that secularity is more attractive is because it's not an ideology. That's precisely because it's not an ideology. It's rather a framework for pluralism. So if we're serious about wanting to have a dialogue, if we're serious about a dialogic approach, then you're going to want to create this constitutional space, and you're going to want to do it in a way which encourages dialogue rather than excludes it. And that involves all of those who are willing and able and wanting to participate in the dialogue on human rights, rather than excluding some actors. Okay, so that's one element that you might derive from this notion of wanting to have a dialogic approach. Now, there are other issues that we can talk about. So, how far you want to build in notions of accommodation, religious accommodation, into human rights practice would be an interesting question. How far religious critiques of human rights can actually be useful in the human rights context. For example, in urging a more sophisticated understanding of relationality as opposed to autonomy, for example. We don't need to get into that. What I'm suggesting is all of that's for the future. But that we need to create this constitutional space in a way that enables that conversation to take place in the serious spaces. Okay. Let's turn to the other side of the coin. So let's assume for the moment that the human rights context rejects fundamentalism and accepts a notion of pluralism. And by the way, I should say that one of the most important and I think relatively underestimated statements of the European Court of Human Rights was one that I quoted yesterday about pluralism. And what it said was, you remember, that in the understanding of religious freedom, it said pluralism is as important for the non-believer as it is for the believer. And why is that? Because it says essentially it's fundamental to democratic understanding that we need a diversity of understandings and approaches in the public sphere in order to have exactly the debate about the fundamentals. So what I'm suggesting is, what philosophers might call an immanent critique. That is, you're trying to draw out of particular institutions what is fundamental to them. It seems to me that one of the things that we can draw from the European Court of Human Rights is that there is actually in their description of pluralism already the seeds for the approach that I've suggested. So this is not new. This is not deus ex machina. This is already embedded in the system, but I think sufficiently buried that it needs to be taken out and brought into real understanding and real practice. Okay, so let's turn to the other side of the coin. What about, is there real possibility of dialogue on the religious side? And equally, there's clearly a significant problem. Now, at this stage, one of the answers I gave to one of the questions yesterday was that I said there are different religions. And some religions are clearly more up for this kind of fundamental dialogue than others. And some traditions within certain traditions, religious traditions, are more up for this kind of dialogue than others. So this is a very complex picture. And you can't have a broad brush approach. It's case by case as to whether or not particular religions at particular times are actually capable or wanting to have a genuine dialogue. But it does have certain implications for how we react to these other religions. So one of the potential problems that arises is that those of us who are not in that religion often identify the most extreme aspects of the religion as the most genuine, authentic parts of that religion. And so if you don't have to be, a particular follower of these debates to know that some of the new atheism, for example, intentionally goes for the crazier, I have to say, aspects of religion, and pulls those out and says, see, this is what they mean by religion. It's crazy. So the effect of that, of course, is that the extremes on both sides benefit from the extremism of the other. So equally, those who are against atheism point to some of the crazier atheists and say, see, that's what they mean by atheism, right? Kind of that. So there is a potential here for a kind of race to the bottom, if you want, where everybody points to the extremes on the other side and says, that's what's most authentic. And that is a self-fulfilling prophecy, of course, because we've already established, if you remember yesterday, the day before, where I said that in market terms, right, you remember I talked about the sort of the market in religions, that there is already a tendency for the more fundamentalist, the more extreme, to be regarded as more authentic and therefore a better brand, a more clear brand. So what we need to be careful about is that not just the religions themselves are driving themselves to the extremes, but that, as it were, liberals outside these churches are also driving them to the extremes, because we identify the extreme as the most authentic. But let's talk about one particular problem in the religious context, which I think is probably a problem that is a common problem to all of the religious traditions that I've been focusing on. So Judaism, Christianity, and Islam. And this is the role of tradition. So time after time, what we see in response to human rights arguments being made that are critical of religion is, if you attack us on this, you're attacking our traditions. And that is unacceptable. You should respect our traditions. And you remember that I pointed out that one of the more, I think, interesting developments over the last few years was this attempt in the Human Rights Council to have human rights redefined by the Russians in a set of resolutions that attempts to incorporate tradition as part of human rights. And what that means, of course, is we say no to gay sex, we say no to same-sex marriage, we say no to women's equality in large measure, we say, and so on. So tradition then is being interpreted as a major block on some of the more progressive interpretations of human rights. So you set up the conflict by saying tradition is untouchable. That's what it means, that's what it's always meant, that's how it remains. So this is not just Islam, this is not just Judaism, large parts of Christianity as well. So what do we do about that? So what I'm going to suggest is that quite recent sociological and anthropological approaches may be quite useful here. And what we find is that when sociologists and anthropologists look at tradition, they distinguish between two different understandings of tradition. And I'll now use Latin terms which have been used to describe these two different aspects. So there's a distinction between traditio and tradita. Okay, what's that distinction mean? So traditio, the understanding of tradition as traditio, is an understanding of tradition as dealing with substance, as dealing with particular substantive rules. So no premarital sex would be a good example of traditio. And a lot of the conservative understandings of, let's call it conservative understandings of tradition, are couched in those terms. They're couched in terms of substantive rules. And most of what liberals hate about tradition is attacking just those kinds of, that kind of understanding of tradition as a set of substantive unchanging rules. And the problem, of course, is that tradition, actually as it operates, isn't very much like that when you look at it in practice. So there's particular aspects of recent understandings of tradition that give a different picture. So first of all, the assumption is that traditio, tradition in that sense, is a set of unchanging understandings how we live based in the past, that have always been that way. And none of that's true. Mostly tradition, as we currently understand it, is a reflection of how we understand the present rather than how we understand the past. In the sense that traditions are often now projected as ways of resisting our understanding of what's going on at the moment. So we find a tradition because we want to resist particular movement or particular change. But it's an understanding of the present rather than necessarily an understanding of the past. Now, of course, we can go through the motions of trying to find the past and justify it, but it's really an understanding of the present. Secondly, traditions are not static. They're always in flux. I don't know of any tradition that is not constantly in flux. And thirdly, the notion that tradition, certainly from liberal critics, is irrational is also, I think, severely questioned. Now, what we now see in terms of anthropology and sociology is that there's often a very important strain of rationality in the adoption and following of tradition, rather than irrationality. But the fourth point is the really important one, and that is that tradition in many contexts is less concerned with the substantive content of the tradition and more with the act of transmission of the tradition. So what we're doing then is distinguishing between traditio, which is the substantive sort of rules, and the process by which the tradition is transmitted over time. So if you're emphasizing the tradition in the sense of the process of transmission over time, that essentially means that it's changeable, that it changes, that it evolves, and that it evolves in terms of our understanding of what the present is. So it reacts therefore to context. It's not static. So the key understanding then, for understanding tradition as process, is that it's necessarily open and responsive to context as part of the practice. So why is that important? Well, why it's important is because if I'm right that there is always this tension within the major religions that I've been talking about in their understanding of tradition as both a set of substantive rules looking to the past, but also as a mode of transmission of values. And I think that is true in all of those religions, but I'm open to dispute on that. It's certainly the case within Christianity. Then that gives a different picture of the openness to dialogue. Why? Because the active transmission of the values is in certain contexts then open to the outside. It's not just an internal debate, because since you're reacting to context, since it's an understanding of the present effectively that's going on, the outside is inevitably going to come in. So is there any purchase in practice in this kind of understanding of tradition as process, as in flux, as rational? And I'm suggesting, at least within the area that I know best, that there is precisely that understanding of tradition, which is within the Catholic tradition. Now, I'm not using this as the only example. I'm betting that it's also true in other traditions, but I certainly know it to be the case within the Catholic tradition. So what you're getting, therefore, is a debate within certain churches as to their understanding of tradition, one of which is backward-looking, rule-based, things have always been this way. The other is concentrating on process, concentrating on openness to context, concentrating on the need to understand that tradition is in flux. So what are the sources of justification for that kind of statement? Well, how would Pope Benedict do? Would that be sufficient authority for you? And in some of the speeches that he made before he retired, this is precisely what he said. Now, whether or not you believe that that's genuinely what he wanted to do is another matter. You have your own judgments about this. But in terms of what he said was precisely along the lines of what I've just described. One of the most important developments in Vatican II, and I'll quote now, was the acceptance that the full implications of human dignity, cannot be known or affirmed apart from the concrete conditions of an historical epoch. Right? Let me just repeat that again. The full implications of human dignity cannot be known or affirmed apart from the concrete conditions of an historical epoch. In other words, that we need to understand tradition as in flux and as reactive to historical epochs. Or how about the Pontifical Council's compendium of the social doctrine of the Church, which I'm sure is something that you have beside your bed and read constantly. So what it says is, it must not be forgotten that the passing of time and the changing of social circumstances will require a constant updating, and here's the key phrase, in order to interpret the new signs of the times. The new signs of the times. So what does that mean? Well, in part what it means is, and I'm now speaking in religious terms, right, for the moment, what it means is the potential that the Holy Spirit, if you want to think of it in those terms, not only operates within the church but outside the church. And that therefore the liberal critique, the human rights critique, the legal critique of the church and of practices that we think of as harming human dignity, that may also be the operation of the Holy Spirit, and therefore should be incorporated within understandings within the church itself. So in other words, just as what we've said, just as the Human Rights Court said, we need a pluralism within civil society if we're going to be democratic. So too, at least on this understanding, the church, at least interpreted in this way, and I'd suggest all churches, all religions, need for themselves to be true to their own traditions, to have this external critique that human rights provides. That's why the necessity and the possibility of dialogue is there. because it's actually within the tradition itself. So in other words, vital to the self-critique, both of democracy and of religions, is the understanding that there are competing understandings of what it means to be human, competing understandings of human dignity, if you want. So in other words, the understanding or the concept of human dignity invites openness to the posing of the question of what it is to be human in our public and communal discourse. A dialogue with those who share that intuition, share the understanding that human dignity is important, but not necessarily the content, whether religious or not, is all the more important because there's something irreducible about the human person that can't be fully captured. So this means that there's always a need for discussion, for the likelihood of disagreement, and for a certain underdetermination, for a remaining disagreement. So the very nature of what we're talking about, the human person, means that we should never presume to be able to specify dignity beyond contestation. No one holds the truth completely. We all share partially in it. And we can only begin to understand the truth as a whole, or at least have glimmerings of an understanding of it, through the kind of dialogue that seems to me to be essential. Thank you.
He has to do, he would probably argue that we shouldn't mix religion with legislation in the articles that I think, like, for example, in the United States, you have the case of, like, whether you teach in certain states, do you teach creative religions and evolution together, or just evolution? He would argue that evolution is in a better position because there's proof, there's proof to cover that evolution exists, whereas if you start teaching the Bible, then what's the difference between teaching every other view and every other religion? So I was wondering what your take on that, because I think that kind of goes hand in hand with what you said about John Paul saying that you shouldn't have any
public reason.
Yeah, or theological understanding. And another question would be just, we talked about in Marcus's course about, for example, about the secular France having the full commands.
The commands,
isn't that to you a violation of liberty of religion?
Yeah.
Great, thank you. So first of all, Richard Dawkins. So Richard Dawkins is almost precisely the best example of what I meant about the identification by liberals of the most extreme aspects of religion in order to, as it were, tar religion with its brush of extremism. And I'm wandering away from my mic, so I don't know what to do.
No, but I mean, Chris, if you have patience to do that, you can walk around.
Good. So is that okay? Thanks. So I'm now broadcasting. It's all very dramatic. So how should one factor in the Dawkins kind of argument? Well, stripped of the point that I've just made, that you shouldn't, I think, identify the most extreme as the most authentic, I have no problems with what he's been saying, because it seems to me to precisely fit with the notion that you need Richard Dawkins, but you shouldn't give Richard Dawkins the opportunity to veto anybody else. In other words, if we're serious about a pluralism of conversations, there's clearly a place for Dawkins, but there's equally a place in the public sphere for those who oppose him and who want to put an alternative understanding. Now, how that conversation then results, what rules, what practices that results in, that has to be part of the dialogue. But to assume, and I think it is an assumption, that truth is always provable in the scientific way, for example, is in itself an ideology. Now, it may well be an ideology that you want to support, but it's an ideological position. And for the state to adopt an ideological position of that strength, I think is problematic. So this is not, I have to say, and this is important because I'm broadcasting, that I'm now going to support creationism being taught in the schools. That's not what I'm saying. But the notion that you want, as I think Richard Dawkins wants, to exclude the notion of religion as inevitably impermissible in terms of the public debate because it doesn't conform to a particular understanding of public reason, which is essentially scientific reasoning, I think is extreme. And essentially what I'm trying to argue against is extremism.
There's also like a parallel to that, what you said to the first lesson about, when, I don't remember the details, but there was this diseased cow.
Yeah,
Want to kill because
exactly, the Krishna cow, yeah.
yeah, so I mean, but I mean that's where kind of reality checks in a certain sense because you're risking like the lives of other cows and people being diseased.
You are.
Because of religious reasons.
Absolutely.
And you can argue that in a way that it's only like scientific reasons.
Absolutely. So nobody gets to be a veto. Nobody gets to have a veto here. So nobody is able to say, because this is my belief, either scientific truth or not scientific truth, therefore I exclude everybody else from the public conversation. That's what I want to try to prevent. So can we come to the burqa ban as another great example? So the problem with the burqa ban, or the issue about the burqa ban, is partly the issue that I mentioned yesterday, which is how should we understand the burqa? And what makes me uneasy about the bans is that it's often quite an essentialist understanding of why people wear the burqa. And it seems to me to be quite a range of reasons, at least in terms of the sociological explanations, as to why people are wearing the burqa. In a sense, it's quite a good illustration of this complex notion of tradition. So the reason why at least some women say they're wearing the burqa is because of traditions within Islam. Whether or not that's true, let's leave to one side. That's essentially also contested, of course, but let's leave that to one side. But it's a good example of a tradition being used as a way of addressing current concerns. Right, so if you are in France, if you're indeed a Muslim in large parts of Europe, it's not surprising if you feel threatened. It's not surprising post 9/11 if you feel that Europe is a hostile atmosphere, at least large parts of it. And so one of the reactions, I think, to that, and I'm not trying to say this is the only reaction, but I suspect it's part of the reaction, is that going into a tradition which in some sense marks you out but enables you to distance yourself from the other society is an important part of how you may be able to cope with that hostility. So I think it's a very, very complex understanding, particularly when the only way of thinking about it is that it is the suppression of women. Now, I've no doubt whatsoever that in some contexts it is precisely that, but in other contexts it's not. In other contexts, I've no doubt that women entirely autonomously are deciding themselves to do that. Now, the problem for law is distinguishing between the two. And I think it is a problem for women's autonomy to say that inevitably women cannot make a fully rational decision to adopt the burqa. I'm not saying they should make that decision. I even might want to say that I would prefer that they didn't for many reasons. But simply to assume they cannot be rational actors, that they must inevitably be being manipulated, I think is way too essentialist and understanding. And a way that is sort of patronizing to the women, some of the women concerned. So I think it's an immensely complicated question. I'm very uneasy about the approach that the French state takes. Precisely because, getting back to the last part of what I was saying, because it seems to adopt what in France, of course, is called laïcité rather than secularism, but it fits very much with the understanding of secularism that I criticized, that it becomes a state ideology, and that makes me very uneasy. Partly because it assumes, I think, that there is only one approach that should be taken to an understanding of what it means to have a republican society. Now, I can understand, and we know historically, of course, why France has adopted that, because of the religion wars and because it actually worked, I think, successfully as an approach of how to compromise between Catholics and Protestants in France. But in terms of how it's dealing with the current situation of Islam, I think it's not working. I think it's ideological, and I think it's unlikely to produce the kind of tolerance that I'm sure France wants, but I don't think is actually expressing at the moment.
Anybody else? No? Well, yes, Benedetta, yes, please.
We're back to the first day, right?
Really, I mean, partially.
Yeah.
So I have two questions. Only one has to do with the moral dimension. The first one has to do with religion. So the first question is, how would you, let's say, connect what you have been saying today with what you said in the first lecture? Namely, today you argued at the end of your lecture that religions, even for their sake, so to say, for the sake of themselves, they need to engage in dialogue. Whereas Tuesday, yes, you are
such a long time ago.
it looks like a long time ago. You argued that religions, you referred that religions, in order to be successful, they also need to be pure, so to distinguish themselves from other religions. So how it is possible at the same time to be pure in order to be successful, if this is the aim or one of the aims of religions, and to engage in this interreligious dialogue without, let's say, losing this purity. The second question relates to the moral dimension. I am sorry again.
Could I try answering the first question, and then we'll get to the second one. So I think you're absolutely right that there is a tension there, and what I think I'm suggesting is that two things. The first is that there's a need within particular religions themselves for the kind of dialogue that you've called an interreligious dialogue to also take place within religions. In other words, what we know clearly is that within the three religions that I've been talking about mostly, there is precisely that kind of dialogue going on, but that very often that isn't recognized externally. So you're right in saying, I think, that there is, and you're quoting me back at myself, to say that there is a pressure to be more extreme for brand identification, but that equally we need to understand that there's a discussion in most religions about how far one should actually be going down that line. I think I'd go further, to be honest, and say that there's a responsibility with for those within religions to engage in precisely that kind of debate and not to allow the brand identification issue to overwhelm what is clearly an important conversation. Within my own church, I think that is happening, but I think it's perhaps been somewhat long in coming, and that it needs to be taken a lot more seriously. And I'd suggest the same within each of the other religions as well. So that's one point, the need for internal dialogue. But there is some things that law can do to offset some of these problems. And that is, I think, for example, when these issues get into litigation, that we shouldn't fall into what I call the Dawkins trap of privileging the traditional, the conservative, as the most authentic expression of the views of that religion. So what we see, contrary to what to the position that my clients took in the JFS case, what you see essentially within the JFS case, you remember this was the Jewish boy, the boy who claimed to be Jewish, wanting to get into a Jewish school. And what you see essentially is going on there is a dialogue within the religion. Right? This is, the Masorti Jewish tradition essentially against the Orthodox tradition. So it's a debate within religion that then gets into court. The courts in those contexts need to be very careful not to privilege one set or other, and that's an immensely difficult task. But I think there are ways of doing it, for example, in the way that evidence is taken, the way that the opinions are expressed by the court, which can minimize that danger of privileging the most extreme. That's the best I can do on that one, but I think you've got another question.
So the other question is if there is a reason, and if there is, what is the reason, why you are referring to morality and the moral sphere rather than to ethics.
Yeah.
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 And also, I missed the first part of your class, so I hope I did not misunderstand what you have been arguing. But especially when you talked about the practice-dependent approach to human rights, and you highlighted some of its limits, I was wondering whether one of its limits was something that an improved practice-dependent approach should take into account, would also be to take this, let's say, moral reasoning into account, not in substantive terms, but as a kind of procedural attitude. Because personally, I think that one of the further critique that could be moved to the practice-dependent approach to human rights is exactly that basing mostly on practices can, let's say, open a space for, let's say, not taking enough into account mental conditioning, adaptation. Yeah. So all those things that would prevent moral reasoning. So would also an improvement in terms of, let's say, pushing forward moral reasoning help the practice-dependent approach to be more effective and so to go beyond its limits?
That's really interesting. So there's two different points, one of which I can deal with easily and the other of which I need to think about, which of course is precisely the reason for your question. So in terms of the language between morals and ethics, for the moment I don't attach any significance to that. If you're happier describing what I've been talking about as an ethical approach rather than a moral, that's fine. I know that there is within the philosophical tradition some who make considerable distinctions between those two, but I'm not buying into that. So you shouldn't attach any particular additional significance to my use of moral rather than ethical. I'm quite happy with ethical also. But your second point I think is a very interesting one. So here's a preliminary response, but I really do want to think about this more. What I'm uneasy about is the notion of second-guessing to a marked degree someone else's ability to reason. So one of the problems, I think, with the Rawlsian public reasons approach is that it excludes from the public realm a set of discourses that are seen to be unacceptable because they are based on a comprehensive understanding. There may be, and I'm not sure whether you are suggesting it, but there may be a suggestion in what you've been saying that one also might want to exclude certain kinds of reasoning on the basis that they're not reasoning at all, they're simply conditioned. Yeah? So this brings us back neatly, I think, to the burqa question. So when we're trying to understand the reasons why some women are wearing the burqa, it's quite easy, I think, but dangerous to say that they're simply conditioned. And therefore they're not really reasoning, and therefore we shouldn't take that into account. So I'm sympathetic to your point about wanting to increase and further reasoning as part of dialogue. But I'm worried about what that might mean in practice in terms of excluding some of the conversations that I think need to take place. Can I throw the question back at you and ask how you would reconcile those two?
Yeah, well, personally, I think that moral reasoning or maybe ethical reasoning,
yeah.
The distinction is basically that ethical reasoning is more dry in a way, or maybe more suitable for the purposes we're searching for. So the idea is that this kind of ethical reasoning requires a critical attitude against things which are happening and critical investigation into the reasons why things are happening. So it requires the comparison and, in this regard, dialogue among different perspectives, each one needing to take the other perspective into account.
Yeah.
Without the necessity, as you argued before, reach an agreement or an overlapping consensus in rules and terms.
Yeah. So I think what I think we're both, if I can suggest where we're both ending up, is the need for a critical reflective attitude, essentially to be adopted as part of the importance of dialogue. That's a good point. So, and I agree with it. Where that leads into real tensions is where one or other party to the dialogue thinks that they considers that they already have the truth.
That would be comprehensive doctrine.
Exactly so. So my suggestion was that in some cases that's the case with regard both to some human rights advocates and to some religious advocates. So the ability, the reason why I'm still struggling with the question about whether there is the possibility of a real dialogue is what happens when the truth intervenes. I mean, personally, I would prefer a situation where people claim to understand the truth, but that it's always provisional, and that it's always open, therefore, to contradiction and to persuasion. And therefore, a comprehensive worldview is fine from my point of view. I think I probably have one, but it's one that I hope is open to the possibility of contradiction. And this is where Dawkins comes in, I think. So I think that applies both to the secular and to the religious. And so the number of times that there have been paradigm shifts in scientific thinking, for example, where things just look very different after a particular discovery than they were before. Think of evolution itself on the scientific level. So I would hope that both science and religion and human rights are open to the possibility of a partial a claim to the truth rather than an unchangeable, never questioned. If there is a refusal to have any critical reflective attitude to one's own beliefs, then I think there isn't a possibility of dialogue. And that's the danger.
A question from you, Juliana, from behind. If you think there is a difference between constitutional rights and human rights?
Yes. So this is a trap, of course. So here's what I think. So there is clearly a difference between constitutional rights and the current set of international human rights instruments. In the sense that the source of authority for why they are law differs. So in the constitutional context, there is a particular tradition, national traditions, as to what constitutes acceptable the Constitution, why the Constitution is law, why it's authoritative. And that may or may not be the same as why international human rights law is law. Now, if you're a Kelsenian and you think that it's all part of the same system, then you may well have a different view on that. Right? For myself, I think that there are sufficient differences in international human rights law from constitutional law to be for that distinction to be kept. What I'm resisting is the notion that the only way of talking about human rights is to refer to international human rights law. In other words, that the category of human rights is one that both constitutional law and international human rights law share to an extent, at least in terms of some overlapping concerns. So that's my first point. My second point is that in terms of the practice at the moment, the interpenetration between the two systems makes a sharp distinction almost impossible now to sustain. A sharp distinction. I'm not saying there's no distinction, but a sharp distinction. In the sense that there's increasing evidence that at the constitutional level, for example, in some states, not all, that international law, irrespective of whether the state has ratified international law, becomes an argumentative point. So think of the Constitutional Court in South Africa. So there's no necessity in the Constitutional Court of South Africa, if you're going to cite international human rights law, in order to interpret the constitutional provisions for the state to have ratified that international law. The court will look at it irrespective. And what I'm suggesting, therefore, is that both international law, when it's interpreting international law, will look at constitutional practice. The European Court of Human Rights does this all the time. And constitutional law, when it's interpreting domestic practice, will look at international law. And so the systems are increasingly interpenetrative. So I'm resisting a sharp distinction, though I clearly recognize there are differences of authority, different rules of recognition, if you like. So I'm not going to get into Carl Schmitt. I'm not going to get into all of that stuff.
Anybody else?
Another trap.
Another trap, yeah.
You were saying about Yukos, the Russian corporation.
Yeah.
So you were saying about corporation with morality.
Yeah.
This is not really preposterous, this sort of connections, or just, as because you said before, it was addressed to the human rights that was fine, that these two terms, moralism and corporation. Usually the common sense is not addressable. What do you think about it?
So if I get the question right, so it's to do with this point that I was making earlier on about the relationship between the Court of Human Rights decision in the UCOS case, which accorded the right to fair trial and the right to property to human right to fair trial and the human right to property to the corporation. And you're asking about that. So personally, I don't think UCOS has a moral right, or indeed an ethical right, if we're going to use ethical language. I think human rights on an ethical or a moral level attached to persons. So I think the notion, and that's of course because I'm deriving, or my understanding, my normative understanding of human rights is based on human dignity, and corporations are not human. So I have no problems with that. I have no problems equally with saying they have constitutional rights. I have no problems with saying they have legal human rights. I just don't think they have moral human rights or ethical human rights. I don't think that's a particularly controversial position.
Well, corporations are driven by lobbies, by money, by...
Exactly so.
So morality is more termed with dignity,
I think we're agreeing.
Anybody else? No? You? Oh, I saw the hand. I'm sorry. Please, feel free to jump in.
I want to say that I really like the way you frame this kind of way forward somehow for human rights. In the sense of your distinction between secularism and secularity, and if I got it right, this idea that human rights basically could be a sort of arena in which competing view and notions of worth, dignity, and rights challenge each other and try to come with a sort of common perspective. And I really like it. Then I have two questions. Don't you think that could be highly kind of utopist in the sense that...
Sorry, I missed...
it's sort of utopia in the sense
utopia.
that at the end of the day, I agree fully with your idea that tradition has something continuous, changing and evolving and answering the challenges of reality. But then you could also say that at the end of the day, the tradition will not exist anymore because they are continuously challenging. So if I bring tradition to a court as endorsement of my position, then actually I'm bringing something which doesn't exist. I'll give you an example. A great deal of the Ugandese reasoning against homosexuality, for instance, or practices of regulating demographical issues, whatever, are based on a representation of tradition, which is a kind of postmodern rereading of masculinity, which is affected very much from fundamentalist groups from the US.
Yes. Yes.
Then I'm worried about what is going to... I mean, we expect the people in the courts to have some huge level of understanding of the nuances of complexity of these dynamics, which is really, scary duties which you are giving to them. And the second question is, this assumes that we have equal relationship in this fora, when of course there are clear balance of power which affect also the decision making.
Yes. Those are both great questions. So I think the essence of the question, if I can boil it down, is whether it's overly optimistic about the capacity of, for example, courts to be able to handle the complexity of the kinds of understandings that I'm suggesting you need in order to be able to cope with these problems. Is that a way of summarizing? Yeah, so I agree with that, that there is a problem. There's two alternative ways of dealing with it. One way of dealing with it is for courts to be a lot more modest as to the issues that they decide they're capable of dealing with. And some of the cases, I think, are instances where the courts enter issues that they really don't understand, and that some greater degree of judicial modesty is appropriate. In other words, it's saying that I would prefer for a lot more of these issues to be determined politically rather than judicially. But then your second point comes in. And your second point comes in both in terms of the issue of balance of power, both at the political level and at the litigation level. So the inequality of power affects the ability of the political process to handle these issues just as much as it affects the difficulty of the judicial process. There's different power imbalances, but there are power imbalances in both. And so what I suppose I'm suggesting is far from utopian, in the sense that what we have is a set of problems that are going to have to be provisionally resolved one way or another for us to move forward. That the inevitability, and we were talking about this last night, I think the inevitability is that some at least of these issues are going to get into court. That courts need to be more sensitive in terms of what they know and what they don't know. And that what they don't know, if they decide it's important for them to know it, they need a lot more sophisticated sources by which to be able to get to know and understand the critical questions. Now, there is, I mean, both of us have been doing this kind of work. I mean, one of the ways in which courts are trying to address this is one of the processes that I mentioned right at the beginning, which is opening up to a wider array of possible arguments coming in through interventions, through amicus curiae, through opening the process of the court, which begins to look in some ways a lot more democratic, in the sense of there being a variety of different voices rather than simply two. Yeah? You can be overly optimistic about that. Some courts have been a lot more enthusiastic in terms of this being a real dialogue than I believe, but it's a possible way forward. The other approach that I think the courts are beginning to think about a bit more is whether they can actually learn from other courts. In other words, that some of the power imbalances, again, I don't want to be overly optimistic or naive about this, but that some of the power imbalances in particular states may be addressed, some of the lack of understanding may be addressed through not having to reinvent the wheel, as we say in English all the time. Right? In other words, that there is now a community of courts out there, and they are increasingly beginning to look at each other, not for solutions, but in part to fill out this question of understanding the problem that they need to confront. And so again, what we see is little steps forward in terms of addressing the kinds of problems that you're rightly pointing to. I don't think they're solutions. They're simply muddling through for the moment. But in a sense, that's what courts do a lot. They muddle through. They're not despite what some of them think, they are not Platonic guardians who are able to act as philosophers. That's not what they do. They muddle through. They do the best they can. That's why all the solutions, that's why all the opinions have to be provisional. So the notion that a decision, particularly in a human rights matter, ends the debate, whether it's the US Supreme Court, whether it's the European Court of Human Rights, that's the end of it. It's not the end of it. It always has to be provisional. It always has to be open to further questioning. And that's why, technically, for those of you who are lawyers, what you'll see is that international human rights courts, and indeed domestic human rights courts, whether they're constitutional courts or otherwise, are much less willing to apply strong doctrines of precedent in human rights cases than probably in any other cases. And what you see is, even in those courts that have a strong doctrine of precedent, that is, you follow what the previous decision was, even in those courts that have a strong doctrine of precedent, very often it's relaxed in human rights cases because of this provisional understanding, because things move on. We just get to know better, what the problem is, and that may call for different solutions. A classic example of this was a few weeks ago in the German Constitutional Court, where actually the burqa ban was an equivalent kind of issue came before the German Constitutional Court. It wasn't the burqa, it wasn't the full-face burqa. It was wearing the headscarf. And 10 or 15 years ago, the German Constitutional Court decided that in order to address this problem, each state, that is each of the Länder in Germany, had to have a law that governed the issue. A couple of weeks ago, it completely reversed itself. And now it says, actually, the way to deal with this problem is that you mustn't have a law that governs all of this, because you're not able to take sufficiently into account the actual nuances in particular situations. The context has to govern. So you shouldn't have a law because it prevents you from making these kind of contextual decisions. So courts are really struggling with these kind of questions, and that's why they can't be regarded as the end of the debate. They can't be regarded as closing down debate. They're another part of the process by which the debate continues.
Yeah, sure, please.
I totally agree with the attention that you had for this linguistic distinction between secularity and secularism. I think I want to highlight this importance because it's the same difference that we have between morality and moralism. And this has to be, I think it's important to distinguish what we are talking about. For example, just I noticed that before you used both terms while you were talking about moralism and morality. So you use both. But there is actually a difference between both.
Yeah.
So this is only to say that it's important the terms we are talking about because of interpretation and misinterpretation.
Yeah.
When we make a law or whatever. So.
I kind of just add to that. I mean, just to agree with you, it's not just the importance of language within a particular language group. Because we're dealing with human rights on a global level, the difficulty of translating between languages here is immense. Yeah. And when I say something, when I say human dignity, and someone is sitting there translating it into Chinese or into Swahili or whatever, I'm never really sure whether, precisely so, whether what I'm saying is what others are hearing. And that's true both in English, but particularly when it's going into another language. Very, very problematic.
This is a barrier
So I'm very, very conscious of the linguistic issue.
And the problem with ism, moralism, or secularism has to do with the negative connotation of ism. Mostly ism are negatively connotated. So, but anyway, this is just...
No, that's right. That's right. I haven't yet heard human rights-ism, but I can imagine it. Maybe that's what I should use as a term for fundamentalism, right? It's now human rights-ism. I think you've just conjured up a new term.
Fundamental and fundamentalism.
Exactly,
Yeah,
yes.
just think of the difference.
Yeah.
Fundamental is something important and positive.
Yeah.
Fundamentalism, of course, is
Yeah.
just the opposite.
Yeah.
So, of course. Well, another thing concerns the... well, of course, we have we know now, thanks to that, human rights has to do with human dignity and with morality. And as we asked, what is human dignity? What is human? What means? So probably a good question is, what is morality? What we intend for morality? Because there are so many ways of intent morality. There is the Catholic morality, Christian morality, the morality as a common understanding. So it's nice that as you ask, you pose this question about dignity. So it's important, I think, also to, well, as far as human rights law and human rights morality has to match, of course. So what kind of morality? Because morality is so different for maybe one nation, another, and as for diversity and the acceptance of diversity, what you said, I recognize it as exactly how languages works. All languages work. There is, of course, we have to cope with the difference. We cannot avoid the difference on languages. So, of course, the problem of interpretation is a real problem. This doesn't mean that you can't tend to a universal. So I'm very interested in this dialogue between universality and differences.
Yeah.
Differences are there and you have to accept it. So is it possible a dialogue in the diversity? Probably is what the conviviality of differences is what we would, probably the aim would be that, a conviviality of differences. And I wonder if the dialogue that, I totally agree with you that the dialogue is so important in every human domain because of the differences there. If this has to do with the difficulty with the dialogue has to do with the fear of accepting alterity. Well, there is something that is different from I fear it. So this is what is the base also of Nazism as well. Or many ideologism has to do with this. So anyway.
I think the short answer is yes.
Okay. Anybody else? No? Let's see hands raised. Okay. No? Girls? No?
Of course we have. Sure.
If you have a question, we have time.
Because I was wondering that the practice-dependent approach does not violate the human rights. Because if we consider the interpretation of human rights, considering the human is clear, very conservative, way, doesn't it really violate the human rights, the norms of human rights?
Why would the practice-dependent approach itself violate norms of human rights? Why? But can you give me more hints here of what you have in mind?
The practice dependent. If we have to consider the cultural aspects about diversity, as she indicated, that it seems to violate the human rights, the norms that if we look at the interpretation of human rights, the resolution of the Secretary General, which came in 1948. If it is not, if it will not be violated with.
Okay, that's interesting. So here's the counter argument to what I've suggested, right? So the counter argument is that opening up all of this stuff to dialogue and to conversation is contrary to the rule-bound understanding of human rights. We have a set of rules. And secondly, it's contrary to the understanding of human rights as extracted from the political process rather than part of the political process. So a legitimate argument is that what I'm suggesting is contrary to the human rights tradition in being non-rule bound and in wanting to incorporate the political into the process. Yeah? And the answer is, no, it's not. And the reason why it's not is because of my starting point. When I said in my kind of attempted reconstruction, I said the general justifying aim of human rights is human dignity. And that is ineffably issues to be discussed in dialogue. That there is no one answer to that. I then said, however, that in terms of how one unpacks, for the moment, that general justifying aim and applies it, there is a whole set of rules and there's a whole set of institutions. But none of those, and here I think all of my human rights friends now depart from what I'm saying, none of those is inevitable. None of those is absolutely necessary. They are provisional mechanisms and institutions for attempting to achieve the general justifying aim, which can also be achieved in other ways. So, do you need a constitution? Do you need a Bill of Rights that sets out all your rights? And many continental jurisdictions, indeed probably most constitutions since 1945 have said yes, you do. That's a necessary part of what it is we mean when we do human rights. But of course it's not. Right? So there are lots of constitutional jurisdictions that have done actually pretty well without having a domestic Bill of Rights. So yes, it can be useful. Sometimes it is, sometimes it isn't. That's dependent on context. So, look at the United Kingdom. Well, in many ways I have a severe critic of the United Kingdom governments serially and separately. But before it had the Human Rights Act, was it a remarkably bad place for human rights? No, it wasn't really. I mean, it had certainly problems in Northern Ireland, and we might talk about those, and it had problems in terms of race, and I'm not trying to cover up any of that. But was it a worse place than Russia that had a very detailed constitutional set of bills of rights? No, it wasn't. So none of these ways of delivering human rights are inevitable or necessary even. That isn't to dismiss them. They are often extremely important in practice. I'm not trying to undermine them at all. But the notion that there is only one way of delivering human dignity, I think is just false. So is it contrary to the fundamentals of human rights to suggest a practice-dependent approach? No, provided you have at the back of your mind that the whole point of this is to deliver ultimately on human dignity. That has to remain a thin but very important moral or ethical underpinning for the whole enterprise. That's what keeps it from being simply a matter of politics. That's what keeps it from being simply a matter of the immediate political needs and interests.
Anybody else? No? No hands raised. Well, I have, probably a few final questions. The first one is that you mentioned, 30 seconds ago, that you come from Northern Ireland, that you were born there. What did that mean in your youth, in your childhood, being a Catholic, right? In Northern Country, which was a region harshly divided into two different religious groups, I'd say political groups, partially identified through their confession, their religion.
Sure.
Okay. So that's my first question.
Can I preface what I'm going to say by an initial expression of unease? Yes? Because generally what I try to do is to distance myself personally from a lot of these discussions. Yeah? So I'm in something of a dilemma here, right? One, because I think the personal does actually affect, but I'm equally uneasy about exposing myself to this gaze because it seems to overly personalize it. Yes, so I'm now expressing an unease about the process, though it's entirely understandable and justified. So to answer the question, how did it affect growing up in Northern Ireland in terms of the issues that we've talked about? Profoundly, but mostly after 1968. So essentially, what very briefly occurred was that 2/3 of the population of Northern Ireland is Protestant, and Protestant in both a confessional sense and also in having political views that want to remain with the United Kingdom. 1/3 of the population is Catholic, and has nationalist views of wanting to be part of Ireland as a whole. So in 1921, very, very, very basically, the island splits into two, with the southern part of Ireland becoming independent, northern part remaining with the United Kingdom. That dispute continues within Northern Ireland because 1/3 of the population doesn't want to be part of the United Kingdom. And so the question of political authority gets translated into religious terms. So Catholics, nationalists, Protestants, Unionists. From 1921 to, let's say, 1937, it was a very tense, hostile place. So, my mother's generation growing up in Belfast, it was a tough place to live. Her father, my grandfather, was a publican. He owned a public house. He owned a bar. And the family stories, we all have family stories. A family story was that there was a sustained attempt at killing leading members of the Catholic middle class, the emerging Catholic middle class. Catholics in Belfast in Northern Ireland tended in the middle class to be either publicans, teachers, priests, or doctors. That was what constituted the Catholic middle class. And so, my grandfather was a target. And, he was in the bar one night, and a Protestant, very important that it was a Protestant came in and said to him, "You won't be coming to the bar tomorrow." And my grandfather said, "Of course, I'm running the bar, why wouldn't I come?" And the guy said, "No, you will not be coming into the bar tomorrow." And what happened? So he didn't. So what happened was that gunmen came in looking for him in order to kill him. And he had been saved by a Protestant. Right? So that's, these family stories are important. So yes, there's a threat, but equally there's some degree of hope on the other side. So how else does it affect? Well, it affects in some way the decision to become a lawyer. In two respects. One, because another family story is that my mother's uncle had been training to be a lawyer. And this is 1921, 22, and was arrested. And interned without trial for a year. So he was imprisoned because he was regarded as a security threat. And only recently I looked up his security file, as we all do. You should always check your relative's security file. Anyway, so I checked my uncle's security file, my mother's uncle's security file. And he'd been arrested because there was a raid by the army in 1921. And a bullet was found after a 2-hour search. One bullet was found after a 2-hour search. The security file listed what else was in the house. And what else was in the house was a whole series of books. And they listed all the books, some of which were obviously subversive. In particular, it said Rousseau. There was a copy of Rousseau in the house. In brackets, in French. Right? So the fact that he had Rousseau was clearly an indication of subversion. It probably was, actually. But you begin to then sensitize yourself to the notion that authority isn't always necessarily terribly sensible and right. But the fact that he was a lawyer and then went on to do work in the community as a lawyer had some effect. But the major effect was 1968. So what happens in 1968 was that prior to 68, the Catholic position, as it were, the nationalist position, was essentially opting out of the state. From 1968, the strategy changes remarkably, and it becomes a civil rights movement. And this is extremely influenced by what's going on in the United States. So the civil rights movement, remember, effectively runs from, well, you can date it from whenever, but say from 54 with Brown versus Board of Education, through the 50s into the 60s with the civil rights demonstrations in particular. Selma has just been, we've just had the anniversary of it. So the civil rights movement was immensely important for my generation, the American civil rights movement. And that leads quite directly to change of strategy in Northern Ireland, and it becomes a civil rights movement rather than a nationalist movement. So part of what's going on in that civil rights movement is that it's a legal movement. And so one of the tools that you use in civil rights is law. So law becomes an element in a strategy for change, a strategy for social justice, a strategy for making things better. And that, I think, was a fundamental reason why I became a lawyer, why increasingly I specialized in equality issues and then in human rights issues. Partly because of this notion that, in a small way, without being megalomaniac about it, but in a small way you can contribute to some kinds of positive change. So I think that's probably, the most important background consideration for the effect of growing up in Northern Ireland having on my future career and future specializations. Deciding to go into, become a professor rather than going into practice, I went to Queen's University Belfast as an undergraduate. So this is between 70 and 74. And this was the height of the then dramatic shift from it being a civil rights debate through to it descending into terrorism. So the resistance by the British government, by the local government, first of all, and then by the British government, to making the kinds of fundamental changes that the civil rights movement were demanding, then leads to a Protestant counter-reaction. So it then becomes sectarianized. It becomes then a dispute between the communities. It then descends into terrorism because there are attacks on the Catholics. Catholics respond, Catholics get armed, Protestants get armed, and the whole thing descends into terrorism. Precisely what didn't happen in the United States. So it's not that civil rights movements are always wonderful and progressive and lead to peaceful resolution. In this case, it didn't. In this case, it descended into terrorism, and vicious terrorism. Thousands of people killed in a small population. So everyone knows somebody who was killed. Everyone knows somebody who was wounded. Living in Belfast at that time, first of all, you realize that, your mother is terrified all the time. Nevertheless, the context of doing law in that situation brings home every day the fundamental nature of law and the fundamental debates, because everything gets translated, of course, into legal terms whenever you're living there and trying to trying to create an understanding of it for yourself. So it was a very, and I shouldn't be saying this, but it was a very exciting time. Yes, it was awful. Yes, it was dangerous. But was it exciting? You bet. Because everything was real. The notion of law being distant from everyday events or from constitutional events, not in this context. When you went in to discuss constitutional law in a seminar, it was not theory. It was lived experience. When you were dealing with criminal law, and you were talking about trials, and you had people interned without trial, this brought it home to you. So the rule of law becomes, an essential aspect of what it means to be able to survive in the society, not just a theoretical question anymore. One of the important elements in the teaching at Queen's at the time was that there was a series of astoundingly good professors. Many of whom had come from outside and were from Africa sometimes, who'd been in Ghana, some in Ghana, some in Tanzania, some in Sudan, and were coming back into the United Kingdom from having been professors abroad. And we're bringing, within the UK legal education, we're bringing a new way of understanding law. Very contextual, very much connected to the society. But theorizing it as contextual. And very influenced by, some of them, by American legal education. Not just in terms of the civil rights issues, but more generally in terms of how one understands law. So the next stage was almost inevitable, which was that I applied for and was given a a wonderful scholarship. Thank you. I'm now looking at YouTube. Thank you, Harkness, for funding 2 years at Yale University, at the law school. And then Yale at the time and since then has been preeminent really in creating a particular program that's targeted at developing professors. So doing the masters at Yale, there was a heavy understanding and emphasis that how one teaches and how one understands law, often through teaching, and that you've got a mission, as it were, to teach. So it was almost inevitable then that I did a doctorate, went back to Oxford, went to Oxford for the first time, did my doctorate there and stayed on. So the progression through to academic life was pretty seamless and a lot more easy than it should have been. And a lot more easy than others have found it, but it was easier than it really should have been. So I taught it at Oxford for a long time, and then decided very late on to qualify for the bar. So I became a barrister in the 2000s. And have practiced a bit since then. Not full-time, nothing like full-time. But one of the interesting aspects of doing human rights is how much, as I think I've tried to explain, how much human rights practice has to be integrated into human rights theory, that you can't really deal with them separately. So doing a bit of human rights practice at the bar certainly has changed my own views of how you integrate the theory and the practice. But that all arises, coming back to your original question, from the initial seeds in Northern Ireland. And that's why, I'm absolutely delighted now to be returning to Belfast, Northern Ireland, back to the roots, in the hope that maybe I can contribute in some way to the further development of the peace process and to using law in that context.
My very final question. You met our students for 3 days. Do you have some piece of advice for them? Any word of wisdom?
Words of wisdom, yeah. So this is when I become. This is the father figure. Yeah.
Pick a figure you fit.
Well, let me say two things. The first is that I have absolutely tremendously enjoyed these conversations, and without I hope overly flattering. Macerata, I think the students and the conversations that we've had are a credit to the university, and to those of you who've been present. So words of advice, I'm not sure are necessary if you're able to produce this level of conversation. Being pushed to answer the question, words of advice, in terms of being a student, get the most out of your professors. They're a resource, and you should be pushing them quite heavily and quite hard to produce the best that they can in order for you to get the most out of it. So there's a responsibility from the professors, from the professoriate, a responsibility I find quite heavy to produce the best that I can. And I think there's a responsibility on all professors to produce the best they can. But equally, there's a responsibility on students to get the best that they can out of the professor. And that means pushing them, and you've pushed me, and absolutely right, you should do that. We did it, I hope, respectfully in all cases. But it's important that students engage in a serious, equal conversation with their professors in order to get the best out of them. So I don't know if it's a word of advice, but it's certainly a word of encouragement that the kinds of processes that we've already been engaging with, that those should continue more generally in any educational context in which you're lucky enough to find yourselves.
Well, I think that's it. Thank you very much, Chris. It's good.
Thank you. Thanks very much. Thank you.